In this lecture, we would like to discuss part 2 of law of insolvency, which relates to the very procedure of insolvency. So, there are 4 stages in the process by which a debtor who has committed an act of insolvency becomes insolvent and ultimately obtains his discharge. So, the first stage is regarding presentation of an insolvency petition either by the debtor or by the creditor. And in the second stage, there would be appointment of an interim receiver at the court's discretion for the purpose of protecting the debtor's property while his affairs are inquired into, and the creditors as a body are given opportunity of expressing their wishes. And in the third stage, there would be adjudication when the debtor is declared insolvent and is divested of his property, which is realized for distribution among his creditors. And the final stage or the fourth stage, that is discharge of insolvent, when the insolvent is released from all liabilities which could rank against his estate in insolvency. So, in that regard, we would like to discuss in brief exactly in regards to order of adjudication, as we found the similar provision under Section 10 of the Presidency Act and Section 10 of the Provincial Act. So, as it provides, if the court is satisfied with the proof and does not dismiss the petition, it shall make order of adjudication. The order of adjudication is an order whereby the debtor, by or against whom an insolvency petition was filed, has been found by the court to be unable to pay his debts. Thus, it is an order of a court declaring a particular debtor as insolvent. The order of adjudication specifies the date by which the debtor must apply for his discharge. So, in relation to adjudication, in regards to solvency, we would like to discuss a doctrine, and that is the doctrine of relation back. The order of adjudication takes effect from a back date and not from the date on which it is made. This is known as the doctrine of relation back. This implies that insolvency commences from a date earlier than the date of the order of adjudication. The date of commencement of insolvency is, however, different under the two insolvency acts. Under the Provincial Act, an order of adjudication relates back to the date of the presentation of the petition, since the insolvency commences with the presentation of the petition. As well, under the Presidency Act, The order of adjudication dates back to the first available act of insolvency, since it is from that date that insolvency is deemed to commence. So the rationale behind the doctrine of relation back is to protect the interest of lawful creditors of the insolvent finding himself in financial stringency. The insolvent might have transferred his property to a person, including his creditor, on the eve of filing an insolvency petition. Such a transaction can be avoided by the official receiver or assignee as the order of adjudication takes effect from a backdate as per the doctrine of relation back. Such a property is realized and utilized for the benefit of the creditors of the insolvent. The transaction which can be avoided include voluntary transfers made by the insolvent within 2 years before the date of the order of adjudication, except those made before and in consideration of marriage or with a bona fide purchaser for a valuable consideration. And also, such transactions include fraudulent preference made by the insolvent if the debtor is adjudged insolvent on a petition filed within 3 months of the date of making such fraudulent preference. However, transfer made before 3 months of the insolvency petition would give the good title to bona fide purchaser for value without notice. Further, any charge created by a decree or otherwise or other transaction in relation to the property after the date of the commencement of insolvency is not binding on the official receiver or assignee. However, bona fide transactions entered into by the insolvent are not affected by the order of adjudication. So also the very other portion dealing with law of insolvency that we would like to discuss, and that is the most important part relating to the property of the insolvent. The term property of the insolvent includes the properties of which he is the owner or over which he has a disposing power. The property of the insolvent may be divided into property available for distribution amongst the creditors and property not so divisible amongst the creditors. The property of an insolvent which is divisible amongst the creditors includes all properties, movable or immovable, for which the insolvent was the owner at the date of commencement of insolvency. Thus, properties like land and building, cash in hand, jewelry, life insurance policies, etc., shall be available for distribution amongst the creditors. So also, properties which may be acquired by or devolve on him after the date of the order of adjudication and before his discharge. Regarding such properties, it has been held that official assignee must intervene and claim the property under the Provincial Act. However, such properties vest automatically in the official receivers. So properties in respect of which he has capacity to exercise such powers as might have been exercised by him for his own benefit at the commencement of the insolvency before his discharge. So all these properties are considered as the properties of the insolvent once before the commencement of the petition or filing of the petition of insolvency. So, in relation to that, also we found properties of which the insolvent is the reputed owner. So, when it is the very question of reputed owner, there is a doctrine which governs, and that very doctrine of reputed ownership. In that regard, it is not only the goods of which the insolvent is the real owner, which vest in the official receiver or assignee, but also the goods which belong to other people of which the insolvent is the apparent or reputed owner. This is known as doctrine of reputed ownership and is applicable in case of traders only. So, for application of this doctrine, certain conditions are required to be satisfied, and such conditions are the goods must be movable, and the goods must be in the possession of the insolvent, and there should be no indication showing that the goods being belong to some other person, and the circumstances must be such that make people believe that the goods belong to the insolvent. So also, the insolvent must be in possession of the good with the consent of the true owner. Thus, the very doctrine of reputed ownership applies only to those goods which are in possession, order, or disposition of the insolvent in trade or business. It does not apply to those goods which are held by the insolvent in the capacity as a belly or trustee or a factor. So the very rationale behind the doctrine of reputed ownership is that the property which has been held out to the world as belonging to the insolvent and on the basis of which his creditors have allowed him the credit should be treated as is and be divided amongst his creditors. The goods which are covered under reputed ownership are sold by the official receiver or assignee, and the sale proceeds become available for distribution amongst the creditors of the insolvent. However, true owner of the goods can claim as a creditor for the value of the goods. So, in that connection, also, we found that the very doctrine of reputed ownership is not applicable to certain properties such as immovable property, goods in possession of the insolvent as a belief. For example, goods taken on hire as a trustee, as an administrator or executor, or any similar capacity of the insolvent. So also, goods which are not in the sole possession of the insolvent, where the insolvent is only one of the possession. So finally, under the law of insolvency, would like to discuss the discharge of insolvent. So what exactly discharge means? Discharge of the insolvent is the last stage in the insolvency proceedings. The discharge of an insolvent implies that all personal disqualification and statutory restrictions which were placed on him by law when he was adjust insolvent have been lifted or removed. The insolvent no more suffers from such disqualifications and is free from them. Thus his status as an insolvent vanishes and he cannot be called an insolvent anymore. He can start his life afresh. The intention of the law in such a discharge is that the debtor, after giving up the whole of his property, shall be a free man again and shall be enabled to earn his livelihood with his efforts once more. So, we found under the law of insolvency, when you trace the very history of development of law of insolvency during the British period, when the Britishers were ruling over India, and especially the Presidency Towns Insolvency Act 1909 and Provincial Towns Insolvency Act 1920. And after the independence of India, somehow in some major cities such as the metropolitan cities, the presidential towns insolvency act is continuing into some extent, in particularly individual insolvents in the metropolitan towns of Chennai, Mumbai, and Calcutta. So in our next upcoming lecture, after discussing the basic fundamental principles governing law of insolvency and the very doctrine of relation back and the doctrine of reputed ownership, in our next upcoming lecture, we would like to discuss the developments made after the independence of India and finally how a code is evolved in 2016 by the central government and by the parliament, and that is Insolvency and Bankruptcy Code of 2016. That how it came into effective functioning that we would like to discuss in our